Okay, Shannon, you can put us on the record.
Okay, go ahead.
This is the matter of Marsh versus Marsh. Was scheduled for an evidentiary hearing this morning at 8:30. Okay, Shannon, you can put us on the record. Nope, that's my fault.
Okay, go ahead.
Hold on. This is the matter of Marsh versus Marsh. Sorry about that, folks. So this matter was scheduled for 8:30. It's now 8:45. I've tried to contact Charmaine Marsh on two different phones. The number does not ring through, which would suggest to me she's got a problem with her telephone. So let's see. Mr. Hotchkiss, this is your client's motion?
It is, Your Honor.
Okay, and Ms. McCluskey is here as the LGAL appointed by the court. So, can you give me a quick refresher of what we are having an evidentiary hearing about this morning, Mr. Hotchkiss?
Yes, Your Honor, thank you. My client filed a motion to change custody in May of 2019. At the time he filed that motion, there were a number of issues that were in existence that he believes established proper cause and or a change in circumstances for this court to reevaluate the custody arrangement. At the time the judgment entered, which was January of 2017, the parties were awarded joint legal, joint physical custody of their children. They actually have 5 children, only 3 children currently remain under the jurisdiction of this court. But the reasons that Mr. Marsh filed his motion was, number one, there were some issues regarding some excessive discipline that had been reported to the Department of Health and Human Services on a few different occasions. Now, he will testify that he didn't report anything. I don't necessarily believe that the reports were substantiated in that the agency took action. I can tell you there's some references to assaults and things of that nature where the mother had struck one or more of the children. I think that's outlined in Ms. McCluskey's reports. And even since then, there have been other issues that have arisen, primarily Ms. Marsh's significant other, Scott Moore, who's also mentioned in Ms. McCluskey's report. Their daughter, Alicia, who is 15 years of age, has experienced some, what she considers very traumatic events by Mr. Moore. There's been accusations that he's taken photographs of her, that he's potentially been outside of her window, even though she couldn't verify for sure that it was him. Somebody made attempts to get into the bathroom while she was in there, and so forth. And Mr. Marsh will testify that he's discussed these events with Ms. Marsh, and Ms. Marsh acknowledged her own concerns about Mr. Marsh, believed that he may have been unfaithful, tried to engage Mr. Marsh in helping surveil him. I think Ms. Marsh has put cameras in the house, she would say, to protect the daughters, but it was more along the lines to protect her significant other, Scott Moore. But Alicia is extremely uncomfortable being around him. In fact, the 3 girls now are staying with Mr. Marsh. They've been there for several months. Maybe since roughly around July. Mom hasn't really reached out to them on too many occasions during that period of time to have contact with them. And quite frankly, there's been a real deterioration and breakdown of the relationship between mom and the 3 girls. I think Mr. Marsh also testified that the 2 oldest children, Joshua and Nicole, who are no longer under the jurisdiction of the court, they did and maybe still do live with dad, and their relationship with mom is almost non-existent. So there are a number of issues that Mr. Marsh will testify to, and he believes that clearly there's a change in circumstances or proper cause, and he also believes that when considering the child custody factors, this court would determine that there's clear and convincing evidence that custody should be changed from joint physical custody to primary physical custody to him. Thank you.
So you mentioned Ms. McCluskey's report. I don't see that in the file.
Okay.
When was that sent out?
Your Honor, I did send that last week. And there was a judge's copy that was marked confidential because it contained comments from the children.
The date of my report, Your Honor, is December 1st. So it's been a while, I think, since the report was authored and issued. I don't, obviously, I don't know what's in the minor children's portion of that report. My client tells me that the children absolutely don't want to go back to mom's to live. They'd like to visit with her, but not to live. I'm not opposed to the court interviewing the children. I know a lot of times that's not necessary when you have a GAL. This particular case is a little unusual because I think Mr. Kelly started as GAL. And then because of some conflict he had maybe with children knowing each other, Ms. McCluskey took over those duties. Now, I don't know whether or not Ms. McCluskey had a chance to interview all the children or just Alicia or what, but I don't have a problem with the court, and nor does my client interviewing the children and getting their preference, even really before going forward with an evidentiary hearing if the court's so inclined.
So Ms. McCluskey, were you able to interview all three of the girls that are still under court jurisdiction?
I interviewed Alicia. I took over the file from Mr. Kelly, as Mr. Hotchkiss indicated. It looks like Alicia, well, this is going to be difficult if the court didn't receive my report, but Alicia was the one.
Let me stop you for a moment.
Yeah.
Did Mr. Kelly interview the other two?
Yes.
So there's something in your report about an interview with all three?
Yeah, very, very detailed notes from all of them. Yeah,
that's sufficient for my purposes. I realize that the perspective of the children is an important factor under the best interest factors. But when I have that input by virtue of a confidential LGAL report, I don't see a need to separately do an interview. It strikes me that's elevating form over substance. But I need to see that report. Did you submit it by email or just by regular mail?
Yeah, I did support it by email last week.
I just checked my email and I don't see it. I don't see it in there.
I can send it directly to the court or to your email right now.
Why don't you do that? And what I will do, I'm going to stop the proceeding. I'm going to read that, and then I'm going to restart. I think that's probably the most efficient way to proceed, because I don't want to have you folks sitting here while I'm reading something.
I apologize, Your Honor. I did email that the confidential one last week.
I don't doubt that you did. I don't know what happened to it, but so have you resent it now?
I'm hitting send as we speak.
Okay. I'll keep you on until I'm sure that I have it. And then we'll take a little break. I'll read the report and then we'll come back on the record. I can leave the meeting room open. I'll just turn off the live stream and have Shannon take us off the record. So I'm glad to see we have a video connection with Mr. Marsh, but sir, you're sharing your screen with us. So it changes the appearance. I'm going to stop that and hopefully we still have you. Oh, interesting. We don't. That was the only way we could get your image up there. That's very strange. All right, like I said, I'll leave the meeting room open and you can play around with that a little bit and hopefully get it solved. And if that doesn't work, we can go back to that screen share. I mean, that'll work for my purposes.
Okay, thank you, Your Honor.
It's odd that that's the only way it's working, but. And I still don't see the report. I wonder if it got captured by my spam filter. Did you send it directly to me when you sent it in the first time?
No, Your Honor, I did not. To the court clerk.
Okay.
And it is in my sent file, so obviously with an attachment, I don't know if that would have taken a couple extra minutes.
Oh, I'm going to check the quarantined messages and see if it's in there. Oh, there it is. Make sure I can open it. Okay, so Shannon, you can take us off the record now.
Okay.